Welcome back to Winning Isn't Easy. Now, when suing your employer for discrimination or termination for exercising your ERISA rights to medical or disability benefits, I've explained that the court will use two possible tests with shifting burdens of proof. There's the Price-Waterhouse direct evidence test, or there's the McDonnell-Douglas pretextual analysis. And you could go back and listen to the first segment of this to kind of refresh your memory. But let's talk about what happened to Mr. Cares because of the cost of bilateral hip replacement. He was terminated and he filed a lawsuit. And he filed both an employment discrimination claim and an ERISA Section 510 retaliation claim after his employer had paid him an $11,458 performance bonus. They fired him 1 week later. Now, he had been diagnosed with degenerative arthritis in both hips. He had undergone one hip replacement surgery, which was covered by the company's self-insured health insurance plan. That's a magic word. Being self-insured means that Southern Pines Trucking paid every penny of the bill. Now, obviously, they had a natural incentive to keep costs low because it was coming out of their bottom line. When the company owner, Patrick Gallagher, learned of the first hip surgery, he was not happy. In fact, witnesses testified at the hearing that he was very, very upset. But things got worse when Gallagher learned that Cares was going to have a second total hip replacement, obviously on the other side. Gallagher was really unhappy that he was paying for not just one, but two total hip replacements, and that was going to cost at least $150,000. So less than 1 week after being paid this bonus, Cares was fired by Gallagher, who made the decision unilaterally. So Cares claimed in his lawsuit that he was fired both because of the cost of his first hip surgery and that Southern Pines wanted to avoid the cost of a second surgery. So he was fired for using his ERISA disability benefits. After hearing testimony, the court decided in the case of Cares versus Southern Pines Trucking, this case out of Pennsylvania, that Cares had met his burden of proof to show that his employer's reason for terminating him was pretextual and that the use of his ERISA disability group health benefits played a determinative role in the termination. And the judge found in his favor, awarding him $67,500 in lost wages and found that his employer had to pay for his attorney's fees and costs. Now, the lesson here is don't give up. Don't let your employer get away from firing you just to deny you your ERISA disability insurance benefits. There is help. And obviously, that help can come in the form of an experienced ERISA disability attorney, or an ERISA group health attorney, and an experienced ERISA attorney who understands 510 retaliation claims. Got it? There is help. Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.